Welcome, everyone, to the Camera Club of Richmond. This is our special event for May of 2024. We are thrilled to have and be able to present to you some law tidbits for the Camera Club of Richmond. And my name is Karen Davis. I'm the Communications Director for the Camera Club, and I'm going to turn it over to Jay Denny, who is our former Exhibit Director. Jay had a great idea to talk about and ask questions on copyright issues as they relate to photographers. And so I'm going to just turn it over to Jay and let him tell you how he came up with this idea and how he knows John and introduce John, and we can have our presentation get rolling. All right. Thanks, everyone.
Thank you very much. John Farmer, I've gotten to know over the last few years, and he writes, teaches on issues around intellectual property, and that's also the focus of his law firm. You see that perhaps on the screen now, Leading Edge Law. And some of you may be familiar with him because he writes a monthly column for the Times-Dispatch in the Monday business section on intellectual property matters. And as we can know and see around us, that area is explosive and changing, and a moving target, I think, is probably the best way to put it. What he's going to do tonight is talk to us, I think, primarily about issues around copyright and ownership as it relates to our photography. And we can talk about that in several different ways, as we've already had a little bit of discussion beforehand. Some of us have been thinking about this for some time and have seen it in different shapes and forms. So he has some prepared remarks, and then we've submitted some questions to him for his consideration. And after those, he will take questions from participants. And what we're going to ask you to do is to put those questions in the chat, and we'll pick them up. But John, first, we want to say how much we really do appreciate you taking time from your busy day to be with us and to give us some insight about what's going on in this field and how it perhaps relates to us as photographers, particularly most of us being amateur photographers. And we realize that this is a snapshot and things could change tomorrow, but we appreciate you taking time to let us know what's going on.
Well, thank you, Jay. It's my pleasure to be with you. You mentioned my column earlier. You can get it in the Times-Dispatch. I'm not pushing you towards this. If you want to read on this stuff and maybe you don't have a subscription or whatever, I put up all of my columns on our firm website and then put them out through LinkedIn, and I'll probably turn that into a newsletter. And if you really want to go deep into the weeds, you can also find off our website my Substack that I run. Generally, my columns are about 750 words because that's the size of the hole I have to fit in at the newspaper, but they're frequently in first draft 1,200 to 2,000 words with a lot more information. So if you really want to dive deep, you can go there. So enough of that. What I thought I would do is once I started seeing the questions roll in that have already been posed, and once I thought about what you probably need to know about, I decided that I probably ought to talk a little bit about copyright registration for photographs up front. That's actually going to address some of y'all's questions. And so I'm going to roll through some slides on that first. And then for the questions I've already received, I will read the question and give you my thoughts on it that I've composed. Now, I don't want to lose anybody, and the danger with being a lawyer in these situations is sometimes you might talk under people and sometimes you might talk over people. I'm not trying to talk down to anyone, but if I start using concepts or stuff that people don't understand, feel free to unmute your mic and just say, hey, John, I didn't understand that. What did you mean by that? If it's more of a follow-up question, tell me more about this, tell me about that. Why don't we handle those at the end? And my plan will be to first go through the questions that were submitted in advance, then take the ones that we get afterwards. So here we are over here. For copyright protection, someone asked about putting a copyright notice on things, and I'll read the question later. And that's good to do, but that's not all you should do. copyright notice doesn't give you the full set of rights you can have. It merely helps you out if you have a claim regarding maybe setting a floor and what sort of damages you can recover. So you put a copyright notice on something to keep someone from claiming they're an innocent infringer, which means to keep them from claiming that they didn't realize that they were dealing with someone else's copyright property. And later, I'm going to get into explaining what sort of floor and damages that creates. So a typical copyright notice looks like the bottom of the screen here. I gave an example using Jay Denny's name, C in the circle, the year of publication, the copyright owner, who's usually the author, which usually will be you, the photographer, unless you've assigned your copyright to someone else or it's a work made for hire. We'll come back to that later. And all rights reserved. If you're really tight for space, you can drop all rights reserved because that more protects you internationally. And so here, right here is the format. Again, see in the circle, your publication, name copyright owner, all rights reserved. Now, again, that only helps you out with damages. The real key to having a remedy if someone infringes your copyright, which means they use your photograph in a way that's not a fair use without your permission, is to have a copyright registration. And so let me tell you some things about that. If you wanted to sue someone for infringing upon your copyright, you have to have a copyright registration before you sue them. And that just doesn't mean apply to register. You actually have to have the registration. Not only that, but if you wait till the infringement occurs and then register, you probably are going to deny yourself access to the sort of meaningful remedies that might make pursuing your case in the first instance worthwhile. In order to have a strong remedy for copyright infringement, you need to register either within 90 days of when you first publish your copyrighted work, such as putting your photo out there publicly, such as in a collection or on your social media or whatever, or before the infringement begins that you wish to attack. Now, of course, you're not going to know in advance when someone's going to go infringe on your picture. And so what that really means is that you should think about having a program of registering your copyrights for your valuable photos, the ones you might care about if someone steals, within 90 days of when you first put them out there, when you first publish them. Okay, so let's talk about the difference in damages between if you get that done and if you don't. If you don't register before the infringement begins or within 90 days of when you first publish, then you're limited to some damages that may be incalculable and they may be zero. And unless your photo gets taken by a really high value use that, you know, there's a lot of money that's gained from the use, it's probably not going to be worthwhile even for any attorney to touch it. So if you don't register, all you can recover are your actual damages, you know, the actual monetary damage you suffered because of the infringement, plus any profits of the infringer attributable to the infringement. Now, the problem here is that both of these numbers might be zero. You might not be able to calculate any specific monetary damage to you, and the use might be such that you can't really trace it to any profit. And so that might be incalculable as zero also. And also, you're not going to be eligible to recover your attorney's fees because you didn't get it registered before the infringement. So that's a pretty bleak picture. I mean, if someone takes one of your photographs and puts it on, you know, makes it like the featured artwork in a movie poster for a valuable movie, then yeah, maybe you've got a claim worth pursuing, but you know, most garden variety infringements you won't. So the way you get some real leverage is to register again before the infringement occurs, and that gives you access to some great things: statutory damages and potentially, although not necessarily, attorney's fees. So if you register beforehand, and if you do it right, and we'll talk about doing it right in a minute, then you can potentially recover up to these dollar amounts for each individual photograph infringed. So The range is between $750 and $30,000 per work infringed. And again, if you do it right, that'd be per photograph. Now, you may wonder, well, where on that spectrum would I fall? And the answer is, I can't tell you. Courts look at a multi-factor test as, how bad it was, how much might have been earned from it, so forth and so on. So somewhere in that range. If the infringement is innocent, the court can go as low as $200 per work infringed, which again means per photograph. That's the reason why you put the copyright notice on there. If you do that, you cut off this possibility and the floor becomes $750 per work infringed or per photo. If you can show that the infringement was willful, then you can go up to $150,000 per work infringed. So, up here, actual damages and profits might be incalculable or zero. Down here, at least you have a range and a floor, and the court can award some money, even if you can't prove meticulously how much someone profited from ripping off your image. The other thing it does is it opens the door to possibly recovering your attorney's fees. I emphasize the word possibly. You probably won't. It's not an automatic recovery. Generally, if you become eligible, you have to show that the other side either took a legal position that was frivolous, not meritorious, or that they litigated in a way that was really jerky and unnecessarily so. So you're probably not going to get attorney's fees even if you register early enough. So that's about damages. So the question then becomes, how do you do this? This is not an infomercial for me. I got plenty of other things to do. But I will tell you up front, I'm about to tell you about how you can do some copyright registration. Doing it yourself is dangerous. I figured, if your choice is going to be not do it at all or try to do it yourself, it's worth a try to do it yourself. But the copyright forms are deceptive in their apparent simplicity, and there are traps for the unwary. And so you might make mistakes in completing your copyright registration, and those mistakes might not manifest themselves until you have to use your registration to go after somebody. And so if you really put value in this, you might look into having an attorney help you do these registrations so that you don't make those mistakes. But again, that's not an infomercial for me. We got plenty to do. So if you're just looking to register a single photograph, you use this form here, Form VA. I put up a link here. Hopefully the link to the slides will be passed around to the membership so you can go click on it. Now, what you don't want to do is if you're registering multiple photos, you don't want to go through any Copyright Office procedure that's called compilation. You don't want to register as a compilation. And the reason is if you register multiple photographs that way, you should end up being limited to one statutory damage for the whole collection. So like if you put in 50 or 200 or whatever, and you put it in as a compilation, and then various photos get infringed, you'd be limited to one statutory damage. And that might not be that much leverage, especially since we saw earlier that you might be limited to $750 a picture. And I know that might be a nice reward for you in the grand scheme of what's worth suing for legally. It's nothing. So how should you go about it? All right. The Copyright Office has some processes specifically set up for group registration of photographs for copyright. And it's set up in such a way that you preserve, if you do it right, your ability to recover one statutory damage for each photograph that gets infringed. There are two processes. One is for published photos, one is for unpublished photos. Publication in the world of copyright means you've put it out there. Now, there's some tough cases, and I may not know the answer as to does this count as publication or that, but I generally think of it as putting it out there. So like, do you deliver it to a client? Do you put it up in your online catalog? Do you put it up on social media showing what you can do? Do you publicly display it at a photography show? Do you put it in a book of your photographs? Maybe I'm not thinking of some ways that you all put things out there. So there's one form for published photos. There's another form for unpublished photos. You get to this by going to the Copyright Office website here. In order to do that, you're going to have to create an account there. I'll go through some screens on that later. So when you get into it, you're going to find these instructions. And I won't read every word in the slides because you can read the slides later, but you've got to complete an online application. You've got to submit a digital copy of each photo. You've got to choose the right form. I talked about that in the previous screen. I'll come back to it later. You've got to decide if you're going to do published photos or unpublished photos. And then you're going to go forth from there. So here are some of the rules. If you're going to do this, each item you put in your group registration has to be a photograph. So you can't mix in like text you want to copyright or drawings you want to copy or anything such as that. Everything you submit has to either be published or unpublished, no mixing. So you can't put in some that have been published and some that have not. There's a limit of 750 photographs per filing for this. The claimant must be the same person or organization. By claimant, this is the person who owns the copyright. Now, if you are filing and you took all the pictures yourself, you're considered to be the author. And so you're also going to be the copyright claimant because you're not going to be handing over ownership to anyone else, I presume. And thus, you're going to file as the claimant. If you maybe have a studio or you have photographers working for you who've given over their ownership to you, then you can claim it along with any of your own. So like, let's say you have 2 photographers working for you, they assign copyright ownership to you, or they agree in writing that their photos are a work made for hire, then you can mix theirs in with yours. You have to give a right name to the title of the group as a whole. You can just say something like J. Denny's Spring 2024 Photographs. Okay, now a little further. What you're going to have to do is set up a sequentially numbered list containing a title and file name for each photo. I have not done this personally. I've just reviewed how it's been done. The Copyright Office has a template for doing that, which supposedly you will find. They suggest that you prepare all this before you actually undergo the process of submitting your application. For published photos, you're going to have to give the month and year of publication for each photo. All of your photos have to have been taken or first published. I'm sorry, not taken, published within the same calendar year. And the application must specify the earliest and most recent date that the photographs were first published during the calendar year. Again, I know we're getting into the weeds. I'm sure you'll go back and review these slides and the Copyright Office instructions if you try to undertake this process. So what I thought I would do is just walk through a few screens of the Copyright Office to show you kind of what this looks like. I'm not going to read it all out to you. And I realize this is probably small text for some of you. So if you go to the Copyright Office and you've created an account through the Electronic Copyright Office called ECO, then you're going to get to this screen and you're going to start preparing your application. And you're going to look over here where it says register a group of photographs, and you're going to click on that. After you click on that, you're going to get to this screen, which is just informational. It's going to tell you a little bit about, this is what you're here to do, register a group of published photographs or unpublished photographs. And it's giving you a heads up as to what you're going to have to do. You're going to provide information. You're going to have to pay the fee. It says upload or mail in. You're going to be mailing in. So you're going to go up here. You're going to click start registration. And when you do that, you're going to get to this screen, and the screen's going to ask, okay, what do you want to do? Are you doing published or unpublished from the drop-down menu? And you're going to pick that. You're going to say you've read the requirements, and you're going to go forward. Then you're going to get to this sort of wordy screen. And this is just going to give you a lot of the rules I've already read to you, such as they're all unpublished in the case of unpublished photographs. This gives you some stuff about the file format for the photos and the list of them. I'm not going to read all this to you. It's pretty straightforward. You'll be able to read it yourself when you get there. Then what you're going to be doing is you're going to be starting a new case with the Copyright Office to start putting this stuff in. You're going to end up on this screen and you're going to hit new. If you look over on the left-hand side here, this is going to show you the steps you're going to go through. And so we did that. We're at this step. My slides don't go all the way to the bottom, but you're going to be going through these steps. So here, you're being asked to give a name to the group of photos. I just chose John Farmer's photos. You can call it whatever you want. You're going to give the year in which you completed taking these or publishing these, and the number of photos, max 250. Okay, so now you've clicked on that and it's in the system, and now you can click continue. Then when you get here, you're going to put in the name of the author. This is really the first screen where I have to tell you, I'm going to give you some information, but this is where the traps for the unwary and the inexperienced really start to show up. And you might read some of these things and you're not quite sure what to put in the blanks. And all I can tell you is that you might figure it out and get it right, or you might get someone to help you. So for here, what it's asking is the name of the author, and an author in the case of a photograph is who took the picture. If someone did that as a work made for hire for you, which means you have to have a written agreement with them in which they agree that the photographs they take are a work made for hire, you are considered to be the author of those photos also, and so you can include that. So you're probably going to be putting in your own name here. If you have a corporation, you can put it over here also. You're going to have to give your citizenship. You're going to have to give the country you live in. It's not going to require your date of birth and date of death. Obviously, if you've already died, you're probably not doing this yourself. The date of birth doesn't really affect much. If you are publishing your photographs anonymously or will be, you might be checking this, or pseudonymously, you'd be checking this, like if you put out your stuff under a different name. All right. So now we're going to identify the copyright claimant. You're going to put that in a second. This is a little different than work made for hire. If you are claiming ownership of photographs that were not assigned to you by a work for hire agreement, or that you didn't take yourself, on this screen, you can indicate that you own it because someone actually assigned copyright ownership to you in a written agreement. It has to be a written agreement. So what you're going to do is go on and put in who the claimant is. Now, again, if you're just going to be doing this for photos you took yourself, then if I go back up, this is going to be you. And this is also going to be you because you don't have a company involved. You're not dealing with anyone else's photographs. You fill out all this stuff. All right. Now let's see. What do we have here now? We want to identify the claimants. Okay, we already did that. And let's see. Do we have anything else? No, I think that's it. So I'm going to stop my share here. Before I go on, does anyone want to ask any questions about the slides I just presented? If so, just unmute. If not, I'm going to go in to start answering the questions that were submitted in advance.
John, in terms of the year that you take a photograph, for example, a lot of us have websites, and let's just say, because that's published, it's out there.
Yes.
And so, you know, I might upload a new gallery of photographs taken this year. That makes perfect sense. But if I have things that have been up for 2 or 3 years, is there any sort of statute of limitations? Can I go back 2, 3, 4 years and do one of these things if I decide to do it for photographs taken in 2022 or 2020 or something like that?
Yes. Yes. And now you need to, if you're going to do this group procedure, you need to limit it to a year, like previously published one set for 22, one set for 23, so forth and so on. If they are all unpublished, you've never put them out there, then I think you can group it together. Let me go back and look and see if I can tell here. Let's see. Yeah, if they're unpublished, I think you could group together ones from multiple years. I'm 95% certain on that, not 100. But if you put them out there, then yeah, you got to break it down by year. Okay?
Yes, thank you.
Okay. If there are any other questions before I go on to the previously submitted questions. Okay, I'm going to go on to the previously submitted questions. If it looks like I'm not looking at you directly, it's because I'm looking at my notes. So I'm just going to go read the questions and I'll start giving the answers. The first one says, in my camera and on my processing software, this person uses Adobe, I can put a copyright mark. Does this give my images copyright protections? If not, what should I do? Okay, we just covered all of that. Brief recap. Copyright notice only helps you defeat the argument that someone's an innocent infringer and thus helps keep them from sinking to a lower level of possible damages. In order to have real protection, you need to register your photograph for copyright, and we just went through how you do all of that. All right, next question. And by the way, as we go along, if it's your question and you don't understand what I'm saying, and if you want to unmute or say, John, explain this better, I don't understand that, please unmute and do that. Next question. Images posted to Facebook or Instagram could be taken and used by other individuals or for commercial purposes for which permission has not been granted. What recourse, if any, do I have? Okay. Unfortunately, your only real recourse is a lawsuit. I mean, you can have an attorney send a demand letter, or if they're still using it, a cease and desist letter, which may also incorporate a demand for money, but there's no way to force action against that person other than suing them, with one exception that I'll bring up a little bit. And so what you want to be doing here is put yourself in the best possible position. And this comes back to what I said earlier. If you had a copyright notice on what you did, and if you have already registered it in advance of the infringement, then you're going to have a stronger economic position with which you can threaten the person essentially and maybe get them to pay you or to pay attention to you than you would otherwise. Now, some of this raises the concept of fair use. And as photographers, you all have probably heard of fair use before. I noticed in the question here, the person said might be taken and used by others or for commercial purposes. So if someone took one of your photos and didn't really use it for a commercial purpose, meaning something that's linked to them making money, then you might not have a claim against them at all. If they are merely displaying the photo, maybe to critique it, such as to critique your photography, or if they've got some other purpose why they need to replicate and show your picture that's maybe educational or for commentary or for criticism, then you might not be able to do anything about it. And as you might imagine, fair use is something in which there are, rows and rows of books filled with opinions as to whether something was fair use in one case or another. I'll tell you, there's a recent Supreme Court case involving a photographer named Lynn Goldsmith that she brought against the Foundation for Andy Warhol. And I won't go through all the nitty-gritty of that case, but I will tell you that in that case, the Supreme Court narrowed when reusing someone else's photograph for, let's say, an artistic purpose would actually be a fair use. Now, one thing you might be able to do short of going to court is if someone put your photograph up on social media, you might be able to go through a complaint process to have the social media site take that down. Most social media sites have online complaint processes for copyright infringements and trademark infringements. They morph from time to time. I haven't done this recently, so I'm not sure if they're going to expect you to have a copyright registration if you want to take down a photo, but you can go look into that if you need. And then let's come back to the economics here. Just so you will know, if someone knocks off one of your photos, it's really not going to be economic for an attorney to get involved to help you unless it's a very high value usage. And it will be much better for you if you've also registered it beforehand. There the parties that do most of the photograph copyright enforcement are the big photo licensing agencies such as Getty. And then there are some mills out there. I'm struggling to remember the name of one of them I've encountered a few times, and they are just set up as sort of sweatshop assembly line things where they may represent photographers. I think they have a large volume of images. Maybe they only work with stock image companies, and they really have it down to a science as far as cranking these things through and sending out letters and emails and all of that stuff. And what they're really good at is at pricing their demands at a price where they recover some money. If they do it at a high enough volume, they can make a little bit on it, but they don't ask for so much that it's worth it for a defendant to go hire an attorney. And so, I'll get those calls every now and then in my firm. Well, I'm not the only attorney here, saying, hey, I got this letter or this email from such and such saying that I ripped off their photograph and they want $2,000 in order to release me from liability. And what I always have to tell them is that it's probably cheaper for you to just pay them than to deal with me, or you could not pay them and hope that they don't follow through and do anything against you. That's just the way the economics of those things go down. All right, let's go on to the next question. As photographers, we often take images of people in public. It might be at an event or just a random image of a streetscape. What issues related to getting a release come into play? Does shooting in public areas and at open events waive the need for a release from the subject? Okay. The last part of the question is easy to answer. No. There's no waiver of the need for a release because the photograph is taken at a public area or an open event. People have a right to control the use of their name, image, or likeness, such as their photograph for a commercial purpose. For those of you who are sports fans, you've probably been hearing about name, image, and likeness, NIL, a lot lately, since that's become the vehicle for effectively paying college athletes independent contractor compensation to go help their favorite college win. So the rules here are unaffected by whether you're shooting in public or at an open event. I've already told you that a person has a right to control his NIL as used for a commercial purpose. Now, you might have a fair use argument if you happen to capture someone in a way that's particularly artistically expressive, but only if your commercial use is as a part of showcasing your expressive ability as a photographer, such as putting that photograph in an art exhibit or a book on artistic photographs. That would not be the case if you're going to go use it for like a commercial stock photo or an advertisement or something like that. The solution here is to either take your photographs in a way in which the people are not readily recognizable, they're turned, they're fuzzy, they're distant, it doesn't really, they're not, a big part of the picture, or to get releases from them. And we're going to talk about releases later. Now, while this is not legal protection, I think you can still use some common sense here. And that is, if you're not going to be realizing substantial revenue or widely distributing the picture that shows someone recognizably, then they're probably not going to care. Or if they do, the claim is probably going to have such low value that no attorney is going to be interested in representing them and harassing you about it. Maybe they harass you a little bit themselves, playing their own lawyer when they're not a lawyer. And so I would use some common sense there. But I think, if you're going to be, if the person's, front and center, you can see their face pretty clearly, you're going to be like selling the image, using it for stock photos, whatever, then I think you need to get a release from them. All right, the next question was, as a follow-up, some events have posted signs at entry points which basically say entrance are granting permission to be photographed. Can this be relied upon? I have some thoughts here. I do not know definitively, and I think it's pretty clear that it depends upon the circumstances. To my knowledge, there's no federal law statute expressly addressing it. I'm pretty doggone confident of that. And it just comes down to general contract law, which is a state-by-state thing. It's possible that some state or locality outside of Virginia might have a statute or ordinance addressing this situation. I'm not familiar with such ones existing. I'm pretty confident, as in nearly certain, Virginia does not have a statute addressing this because, again, it's an issue of contract law. So when you look at these signs and you think about, does this cover you? You need to think in terms of the way contracts are formed and found to be enforceable. This is the same line of thinking that attorneys use in analyzing whether click wrap agreements on websites or terms and conditions on websites can be enforced as contracts. In order to have an enforceable contract, which is really what we're talking about here, you need to be able to show three things. You need to be able to show that the person whose agreement you're seeking, like the person coming into the event, was put on full and clear notice of what you're proposing, such as if you walk in here, we can take your photo and use it for commercial purpose. You need to show that that proposal, that notice was unavoidable. In other words, you couldn't have gotten in unless you walked past and saw the sign and it was positioned in such a way that you would have had to have read it. And there has to be some sort of affirmative manifestation of assent, in other words, agreement to the proposal. What can you point to say that the person understood what the deal was, what the terms and conditions were, and chose to come in anyway, and thereby they agreed? So let's roll through how you think about that. First of all, you need to ask yourself, did the sign unambiguously disclose everything that you want to do and end up doing with the photographs? So, if it's going to be, we might use it for a commercial purpose. Okay, is it just to promote the organization who's having the event, or might you take it and put it in a stock photo thing that you license out to others? Was it really unavoidable? Was there, were all the entrances covered with this? And was it front and center in such a way that you can't see it? And then you have to think about whether the person is really agreeing to what you put out there. And there I wonder about whether there are some situations where it's not fair to say that someone who chose to come in walking past the sign has really agreed. What if it's a necessary ceremony? Like, what if it's a graduation or swearing in or some sort of thing that you have to do to be credentialed to do something? Then I would worry about whether you can really say someone agreed to your terms by going in, because they might really didn't have a practical choice as to whether to come in or not. So I would think about that. Or if someone, before they got there and knew that you were going to be doing this and saw your sign, had already paid a non-trivial sum to attend the event, then they might show up and say, well, geez, I really don't want my photograph to be used for some commercial purpose, but I already paid $100 to attend this event. And so, how am I going to get my $100 back if I don't agree to all of this? The other thing you need to think about is who has permission. You got to think about how permission on the sign flows through to whoever is actually going to be using, perhaps commercializing the image. And so, does the sign cover just the event organizer, or does the sign say that the license is given to the photographer? Is the photographer the one doing the commercialization? If it's not, how does that approval flow through to that person? Those are all things that you would need to cover on this sign. Here's the bottom line. I think if you're trying to make certain you've got permission for anything that might be high value, such as things you expect to commercially exploit extensively, or maybe there are celebrities involved, well-known public figures, I wouldn't try relying on a sign. If it's, just garden variety usage, you're not going to be making much or any money off of it. You're not dealing with celebrities. It's a low value situation. Then maybe you feel a bit more comfortable. All right, let's go on to the next question. Is there an internet site you would recommend to find a standard photography release form? No, there isn't. I will tell you that my view generally here is that when you go online looking for a free legal form, which this is, or contract or whatever, you get what you pay for. My view here is that there is no such thing as a standard photography release. They always need to be customized to the situation. There are so many different factors that you need to take into account. And I'm not going to try to list all of them because there are a zillion of them. But for instance, are you going to be, are there going to be any people in these pictures who are children or people who are not capable of giving their own consent? What specific purposes are you looking to have licensed by the release? The release is not a just, okay, you can use a photo. You got to think about, do you need to cover commercial? Do you need to cover promotional? Do you need to cover editorial? Do you need to cover political? Overall, would the picture be used to imply endorsement of any specific goods or services? Will there be any consideration paid? If so, what are the payment terms? Are there any limitations on how the photo can be used, such as sensitive or controversial purposes? Is someone being paid to give the release? Are you asking the person for an indemnity, defense, and hold harmless against anyone later making a claim over you using a picture containing a portrayal of that person? What state law is going to govern? Is there mandatory jurisdiction for the case in a specific course? Are you going to mandate mediation or arbitration? Are you going to put in a damage limitation? There are just so many different things that I'd say either, take your chances, ask ChatGPT to write one, go look on the internet, realize that it may not do what you need it to do, but it's better than nothing. Or if it's meaningful enough to you, I suppose you could hire someone to talk to you about the types of uses that you might be engaged in and write one that's really addressed to that. And I realize most of y'all are amateur photographers, so you're probably not going to make that investment, and that's fine. All right, let's see. I think we've got 4 more questions, and we'll open the floor, unless I haven't looked in the chat to see if there are any others there yet. Next question, how about one for a minor where you need parental permission? Okay, I don't have specific knowledge on that because that's not really a copyright issue. That's a what about minors issue. It makes sense to me that an adult with power to act legally on behalf of a child should be able to give contractual consent. If I was dealing with a situation where it's a minor and there's a high value or controversial situation involved in the photography, then I think I would drill down really hard in the law with the aid of a lawyer to dive into the ability to bind a minor legally in that jurisdiction and in that specific situation, because otherwise you face the risk that that minor then becomes an adult and you haven't covered it well and they come after you. All right, next question. Do you need to give a copy of the release to the individuals who are doing the releasing? Legally, I don't see why you have to do that. I don't think it's necessary to form a binding contract. I'm not aware of some sort of consumer protection law that requires you to do so. That's always possible. While there's some federal consumer protection law, mainly through the Federal Trade Commission, that's generally a state-by-state statute thing, and sometimes locality by locality. Under general contract law principles, someone can be bound by a contract even if they don't possess a copy of what they are signing afterwards. That said, use some common sense. If you give a copy to the person, that might be just good human relations with that person so that they're unlikely to raise a problem later, and it might help remind them of what they've agreed to do so and thus discourage them from making some sort of nuisance or frivolous claim later. The most important thing is for you to keep the signed copy of the release. you've got to have you need to hold on to that. It's not sufficient to say, oh, well, here's the form of the release I was using back in 2022, and I know that John Doe or Jane Doe signed it, so that's what they agreed to. No, you need to have the release with their signature on it, and their name's got to be printed on it so you can tell who the signature is, and it probably should be dated, so forth and so on. Penultimate question. If you are doing a shoot for compensation, can you build the photography release into the agreement you ask for the parties to sign? If I correctly understand your question, the answer is yeah, you could put those two things together. I mean, those are just two kinds of contracts. You can make it into one contract. So that shouldn't be a problem. Let's see. I have one comment here I'm reading to myself. The only thing I had was that keep in mind that the release needs to come from the person who will be depicted. And that might not be the person who's signing your contract for you to work for them. So for example, if you're doing a photo shoot for a corporate client, maybe you're taking pictures at the workplace, and the pictures are going to be used on a website to promote the goods or services of the company, then whoever is going to own these things and use these things has to think about not just the fact that the company signed up for your services, but how are the releases being gathered for the individual people that are going to be shown in it, such as the employees or visitors at the company. You've got to get that from them. Now, maybe it'll become the responsibility of the company to get that. Maybe in your agreement, you'll provide that the company is responsible for getting all of that, and they will indemnify, defend, and hold you harmless from any claims people in the pictures might make, the different ways to get there, but you need to be thinking through all of that. Last question I got in advance, it says, it's my understanding that the artist photographers can now take copyright issues to small claims court. Can you tell us about any examples of copyright claims that you know of that have been presented in small claims court in the Richmond metro area, and what were the outcomes? Unfortunately, I don't have anything for you. I'm not aware of any cases filed in the Richmond metro area. Matter of fact, I've not tracked any anywhere. I have not handled any, and I don't anticipate doing so. I'm under the impression that that process has gotten very little traction. So if someone has actually done it and had experience with it, when I finish answering the question, speak up and tell us about it. There are some real limitations there that are mainly going to keep attorneys away from even getting involved with it. The first thing you should know is a defendant can decline to participate in the litigation. So there's the small claims court, but if you sue, I put that in air quotes, someone through it, the person can just decline. They can just say, I choose not to do this. You can sue me in federal court if you want to. You can't require a defendant to go through this. And that's because under our Constitution, you have a right to a trial by jury, which means in the case of federal law, because copyright is federal, going into a federal court. So you can't force the defendant to proceed. Also, when I looked at this, I once did a deep study in this and wrote about all the procedures and everything, and then I realized nothing was going to come of it. There's a pretty low cap on how much can be recovered. I think it's $30,000 per proceeding with a statutory damages cap of $15,000. I think that's right. I'm not 100% certain. I know that sounds like a lot of money, but you can blow through that amount of money really quickly with having an attorney represent you in something, and you easily could run up several $1,000s, even if it's a copyright small claims court thing. As a matter of fact, when I looked at the process, what I concluded is most IP lawyers are not going to touch this. It's not going to be economic. Those that might, and I don't know of any that do, would have to be ones that really built up a high volume production mill practice based upon this, where they've sort of got all the forms and all the templates set up, and maybe they've got some non-lawyer administrative staff or cheaper who can do the intake and just kind of pump these things out and bring down the cost per case. And even then, you probably still spend a four-figure sum. But, you know, for any normal IP attorney, you know, each case is a snowflake and you've got to do custom things for it. And it's hard for the economics of working with that to take place, which all of this circles back to where we started. You know, if you register your copyright in advance and you use a copyright notice, then if the conduct is egregious enough, you may have potential enough of statutory damages to get an attorney interested. Whereas if you didn't do those things, you probably won't, unless your photo is used by some major Madison Avenue or Hollywood purpose. I think that's all the questions I got.
John, the one that came in the chat that had to deal with published and unpublished. If you have unpublished photographs, how would someone get to them? What would be sort of the reason to do that? You anticipate publishing them? Is that the primary reason?
Yes. It makes life easier. If you do it all in a batch before you publish them, you're covered after you publish them. You don't have to register again. And that saves you the rigmarole of having to say, well, this photo is published on this date, and this other photo is published on this other date. And also that keeps out of the question did the infringement occur before you registered? Now you've got 90 days after publication to register, but this just keeps it nice and clean. You got it registered beforehand. And so there's no issue of whether it was registered at the time that the problem occurred.
I think that was it, unless I missed something, but I think that's all the questions that we had.
Let's see. I think I see some new messages. Let me see. I think there are a few. Let me just read through them. If we post a photo on a social media site and then file a copyright after we post it, do we have the same protection as we would if we had filed for copyright before we post the photo? Well, protection just comes from, one, using the copyright notice to cut off innocent infringer, and two, by putting it on a social media site, you have published it. So if you're going to get registration protection, you've got to do the registration before it's infringed. And if you've already put in a social media site, it's going to count as a published photo. So you got to go through the process for published photos. Next question. In most legal battles, the plaintiff has to show an economic loss, which in some photographic circumstances would be hard to quantify. In an example of a person who did not pay for a ticket to watch a movie, the only demonstrated loss is the cost of the ticket. But in the viewing or the theft of the image, it seems like there could be a punitive component. Well, that's what we covered earlier, and that is, you know, actual damages and profits you can get if you weren't registered in advance, which you can get if you are registered. So I think we went through that pretty well. Someone says, someone downloaded an image from my website without permission, gave it to someone else who painted it exactly, then wanted to enter a competition where they could potentially win money. This is quite some time ago, but I'm curious, what rights recourse would I have? Well, there's a lot to unbundle there. I will say that making a derivative work of someone else's copyright property is a infringement. And so if someone painted it exactly, then I would say that if you've got a solid copyright on your photograph, they're making a painting copy of that would be an infringement unless it qualifies as a fair use. You say potentially could win money. If they just put it out there for artistic purposes and made no money from it, maybe it's an infringement, but there are no damages. And if you didn't register your copyright in advance, there's no statutory damages. If they actually won a substantial sum of money, then maybe you'd have a claim against them. Unless it's really substantial, it's probably not worth pursuing. But that's a hypothetical in which you could go, well, it's not hypothetical to you, I realize that could go through a lot of facts. And then someone asked the question, I think this is what you just asked, Jay, if it's unpublished, how could they get access? And I think we went through all of that. And, you know,
Right.
the whole idea is to register before it's published so you don't have to deal with the did you register in time question. Anyone else have any other questions? If so, feel free to unmute and just speak. Or if you just have a comment, or maybe you've tried the Copyright Small Claims Court and tell us about it.
So I actually have a quick question. And first, thank you. Very helpful, very informative talk. Really appreciate it.
Sure.
So I give the Camera Club of Richmond a couple of photos, you know, every other month to put up on the screens during a meeting and get evaluated by some, you know, some photographer, professional evaluator, et cetera. Those images then sometimes end up being published on the club's Facebook page. Does that make either of those or both of those activities make the image published versus unpublished?
I'm sure putting it on the Facebook page does. I'm not certain about if it's just privately shared in a group. Probably that qualifies, but certainly putting it on social media is going to trigger it having published status.
Well, I think we're also doing, John, when we do those programs and those images are done, we're making a video and we're putting it up on YouTube. So that's another social media way we get it out there.
Yeah, that's going to be publication also.
Okay.
I thought that we had a statement from in the club's bylaws or whatever that says once you give your image to the process, then it's not that you've relinquished your rights, but it becomes a social media publication and people would have access to it, and what they do with it is pertinent to what we've been talking about here. But I don't think that unless you've jumped through all the hoops and had it registered beforehand that you have much to say about it.
No, the question was just, so let's say that you want to now register a copyright on an image you shared with the Camera Club of Richmond. You need to do it through the process that is for published photos.
Yeah.
Right. You can always do a one-off through the slide I gave you towards the beginning. When you go back and review that, or you go, I think that you should have access to the slides, or they'll provide it to you where you can get in there. I made them, anyone who's got the link can look at them. There's a form for a single photograph. And then there, of course, if you want to do the group stuff we talked about, you can do that. And that's how you'd register your copyright.
But, you know, Martin, it seems like this is getting a little bit back to the situation that John was talking about, where someone is giving a claimant or an author permission to do something. The copy, you sort of the copy has the copyright been transferred. So the question would certainly be, let's assume that somebody took one of the images that I posted for one of our meetings or one of our end of the year competitions and used it. Is it me who's going after them, or is it the Camera Club? Because who have they violated? I think that's just sort of to me, that's an open kind of question. So
it's sort of like Heidi's question about if you took one of her images and then used it for something else, either a painting or whatever, then, you know, it's twice removed, but what are the damages? And
right.
if they won $1 million, it would be different. But if they didn't win or won $45, I think it's pat yourself on the back that they used your image, and otherwise I think you've got no case.
I'm not so sure about that. If I can jump in, the copyright owner, whoever that is, still has a claim. And so, for instance, if Jay took the photo, owns the copyright to the photo, he's still the copyright owner. And if someone infringes upon it down the road, he still potentially has a claim against them. And so the questions I would ask in that case are, was there something by how Jay let the club use it, or something about how the club held the photograph out to others that granted a license to the public to to use it without further license, royalty free or public domain. So, you know, if you haven't through your process of taking the photo from the photographer to the club, or by the club putting it out there, if you haven't held the photograph out as public domain or royalty free or whatever, it seems to me that the person who owns the copyright, who's probably the photographer, still has a claim. And then you just get back into how much is it worth? And that gets into, did you register it before the infringement occurred?
Great, great.
Thank you so much. Any other questions?
John,
John?
thank you very much. It was very informative, and the club gives its heartiness approval for this. I hope a lot of people will look at it and listen to the presentation afterwards. I think people will.
That's fine. I mean, it's my honor to do it. And then you can just, you know, whoever wants to watch the videos, that's fine. Whoever wants to click on and read the slides, that's fine. You know, it caused me to go brush up a little bit on this myself, because I knew that there were group ways to do these photos things. I don't come across that often and haven't in quite a while. So it helped me go refresh that myself.
I saw on a news feed today, 2 photographers were suing one of the AI companies about their image being used as a format for an AI development.
I know all about that. Yeah, there a bunch of content creators have been going after the AIs for that. I've done a lot of writing on that. I think as far as use for training data, they've got a very shaky claim. If the AI actually spits out one of their images, then there might be a claim. And early it was thought that the nature of AI wouldn't cause that to happen, but now it's not necessarily looking like that's the case. The other sort of claims that are being brought here is that sometimes the photo has copyright ownership information on it, like your copyright notice, and that gets garbled or deleted when the AI spits it out, if it spits it out, which should be rare. And some are arguing that there's a separate claim for having your copyright management information stripped from your photograph beyond the infringement itself. One thing I should have mentioned earlier, I know y'all want to go soon, so I'll stop talking very quickly, is there's a big misconception on the internet that giving credit is sufficient to avoid needing to get permission. And so people will go on social media, including celebrities, and they'll see photographs they want, and then they will, you know, repost them on Instagram or wherever. And they'll put in the thing, oh, credit to so-and-so, I got this photograph here. Credit does not equal permission. You can give credit and still be a copyright infringer, and whether you gave credit or not really doesn't have any bearing on whether you're a copyright infringer. This comes up all the time with stupid celebrities, and that is, you know, professional paparazzi will be out there shooting pictures of them, and they'll take some picture of the star, and the star will like it, and she or he will repost it to their Instagram and think because they gave credit that they're covered, and they didn't. And some of them have been sued for that and hit pretty hard.
Wow.
John, we thank you so much. It's been very helpful, and appreciate you taking time to do it. And look forward to seeing you sometime again soon. Thank you so much.
All right. Take care, everybody. Thanks for having me. Good night.
Night.